Welcome to the Business Rescue Boardroom. Good day and welcome in the Business Rescue Boardroom. My name is George Nell. I'm a senior business rescue practitioner and a practicing attorney. I've done more than 130 business rescue projects and has a master's degree in this field. Today with me in the boardroom is my colleague Gideon Slabbert. Welcome, Gideon.
Thank you, George. As George has introduced me, I am a business rescue practitioner. I have concluded my studies in the field of entrepreneurship, business management, and financial analysis. I have concluded my certified rescue analyst program at the University of Pretoria, and I am a member of the Turnaround Management Association of South Africa. So, George, what is business rescue?
Well, business rescue is a process where you focus on the rehabilitation of a financially distressed company. Since the inception of the Act in 2011 on the 1st of May, in pursuance to the judicial management, which never really worked, business rescue was enacted and business rescue practitioners was appointed to rehabilitate the companies that was financially distressed. As an analyst, you understand the financial distress of a company and can explain it to the people with us in the boardroom today.
Yes, thanks. This is always one of the topics that has got numerous answers that one has to evaluate. First of all, the Act refers us to financially distressed companies as companies that cannot pay their debt immediately or in the ensuing 6 months. As business rescue practitioner, my experience is when there is no cash flow in the company. Usually, we would find that the creditors are demanding, they would want payment, and the board of directors or the senior management of the company find themselves in a position where they are firefighting to the creditors that is shouting the loudest or demanding their money.
Yes.
So this would also be coupled with the fact that you cannot necessarily pay your salaries. You are battling to finance your cost of sales, and you are just struggling with your operations. So on board level, usually a quick indicator is to assess the solvency of the company. And this is where we compare the total assets to the total liabilities.
Yes.
I have also found that a lot of the times the financial statements of companies overstate the assets. So it would seem that you are solvent, but actually, if you look at the market value of the assets or the saleability of the assets, you are actually insolvent. So solvency together with cash flow is the greatest indicator for financial distress. And if it would seem cash is king at the end of the day, and if it would seem that you cannot pay your operations, you would most definitely need to consider business rescue. So in saying that, George, you mentioned the general moratorium. What is the general moratorium that business rescue legislation provides a company?
Gideon, yes, I would say that is the main purpose initially of a business rescue. The guys sitting around the boardroom table, the directors of the company, are inundated with phone calls from creditors, and they just want to, the firefighting as you stated, they just want a little bit of rest. But in the meantime, there is people planning to sue the company, to liquidate the company, and the like. So if the board finds that a company is financially distressed, they actually should and must, and this program is not legal advice or financial advice, it is only a discussion about business rescue. They should and they must put the entity into business rescue. The first thing is that the aim will be the rehabilitation of the company, but the moratorium on legal actions is a nice tool to have because the company will not be able to be sued and or liquidated in that period of business rescue. Why the business rescue practitioner, who is a very important appointment, we will discuss it just later on, while the business rescue practitioner in conjunction with the board, the management, the creditors and the employees develop a business rescue plan that must be voted on at a later stage, and 75% of creditors must vote in favor of that specific plan. Now, the practitioners that is out there, what must they have to become a business rescue practitioner, in your view, Gideon?
Well, in my view, and what the Act requires, it is actually a regulated process or procedure. Business rescue practitioners have to have the right qualifications and experience. They have to have a certificate with any SAQA approved professional institution, and
the letter of good standing as well.
The letter of good standing that the professional institution provides. But then also, as a last stop, the CIPC also regulates the industry, and they also certify practitioners based on all the requirements in the industry. How do we guide companies in choosing a practitioner?
It is. That's a good question, Gideon. You get lawyers like myself that practice as business rescue practitioners, business analysts as yourself that practice as business rescue practitioners, and chartered accountants and the like. So firstly, that decision is the most important decision after putting the business into business rescue, is the most important decision. Who are you going to appoint as a business rescue practitioner? Read about the business legislation, business rescue legislation. Ask around about business rescue practitioners. Just don't take the first guy that walks into your office. There must be some technical knowledge about the field that you do your business in, mining, construction, transport, and things like that. But the main thing is the business rescue practitioner must not be a miner or a transporter. He must understand the business legislation and financial part of business rescue. So choose a person that's got integrity, that you've tested with get a CV from that person, and that person you should choose as your business rescue practitioner.
So just one question, maybe reverting back to the general moratorium, and it's an interesting one, is one can enter business rescue either through voluntary resolution of a board of directors or per court order. What does a company do if a liquidation application has been filed against the company?
Yeah, then sorry to interrupt you there. Then the board has got the authority of the board to take a resolution. Then there is no authority anymore. Then an intervening application to court must be brought in terms of Section 131 of the Act to put the entity into business rescue, and you have to convince the court that there is a reasonable prospect of rescuing the business.
So in understanding what you have just said, business rescue can supersede liquidation applications?
Yes, definitely so. When you issue an intervening application for business rescue, all liquidation proceedings are frozen, and the court adjudicate on that application. So sometimes business people utilize business rescue wrongly so to stop a liquidation application. But I would say that the board of directors should timelessly think about their financial position and timelessly take a decision to go into business rescue. There must be a little bit of diesel in the tank, so to speak, to have a proper business rescue. If you're depleted of any energy, a business rescue most probably will end up in a liquidation, unfortunately. But if you've got post-commencement finance and some diesel in the tank, then I think a business rescue can work, definitely.